Hello everyone, I am Anuj Nakade and welcome to LiveLaw. There is important news from the Supreme Court in the ongoing dispute over governance of Delhi between the Lieutenant Governor of Delhi and the legislative government of NCT Delhi. The Supreme Court has decided to refer the present dispute about the 2023 Ordinance to a 5-judge constitutional bench. This is the second time that the government of NCT Delhi and the Lieutenant Governor have been involved in a litigation that has been referred to a constitutional bench this year. If you've been watching our channel for a while, you would know that we've covered this issue just 3 days ago when it came up in the Supreme Court. Since we covered the details of the case in 2 previous videos, there is a link in the description to the previous videos for you to watch, and we will give only a brief summary of the story of the disputes between the Lieutenant Governor and the government of Delhi in this video. The Union Territory of Delhi is unlike most union territories in the country. It has a legislative assembly like the other states, but at the same time, it has executive control by the President of India through the Lieutenant Governor, as opposed to states who have a legislative assembly and an executive government. So, in 2014, the Delhi government approached the Delhi High Court for control over administrative services, electricity, and so on. The Delhi High Court said that while Delhi has a legislative assembly, it still is a union territory and the president should administer it through the LG, curtailing the powers of the elected Delhi government. An appeal was filed in the Supreme Court by the Delhi government against the order of the Delhi High Court. A 2-judge bench bifurcated some powers between the Delhi government and the LG. However, this 2-judge bench referred the issue of control over services like administrative services to a 3-judge bench. This matter was then referred to a 5-judge bench by the 3-judge bench. In May of this year, a 5-judge bench gave the government of National Captial Territory of Delhi control over all services except police, public order and land in the May of this year. However, soon after the judgment, on May 19th, the President of India introduced the Government of National Captial Territory Amendment Ordinance of 2023. This ordinance, in effect, deprived the Delhi government of the power over services, which is essentially contrary to the judgment of the Supreme Court in May. The ordinance in question envisions a committee comprising of the Chief Minister and 2 senior bureaucrats, which will make the recommendations to the Lieutenant Governor regarding transfer and appointment of civil servants, and the LG will have sole discretion in taking this decision. As a result, the Delhi government then approached the Supreme Court with a writ petition challenging the ordinance of 2023. On July 17, the Monday of this week, a bench of Justice D.Y. Chandrachud, Justice Manoj Misra and Justice P.S. Narasimha indicated their will to refer the matter to a constitutional bench. We did a pretty detailed coverage of that proceeding on this channel, and the link to the same is in the description for you to watch as well. The short version of that story is that the Supreme Court had contemplated referring the matter to a constitution bench since the 2018 judgment, the 2-judge bench judgment that we previously talked about, and the 2023 judgment, the 5-judge bench judgment that we previously talked about in this dispute, did not cover Article 239AA7A, and Senior Advocate Dr. Singhvi had sought an opportunity to argue against referring the matter to a constitution bench. Today, on the 20th of July, the same bench has passed an order to refer the matter to a larger constitution bench. Senior Advocate Dr. Abhishek Manu Singhvi appeared for the government of NCT Delhi and argued that a reference to a larger bench is not necessary and that it is an issue that can be decided by the 3-judge bench. He contended that the ordinance was against the provisions of Article 239AA as it dilutes the powers of the elected government. Senior Advocate Dr. Singhvi then also argued that if the matter is to be referred nonetheless, then a priority hearing is to be given to the matter ahead of the Constitution Bench hearing for Article 370 cases, as the issue is a short point. However, the bench made it clear that it cannot change the schedule of Article 370 hearings. Senior Advocate Harish Sarve, appearing for the Delhi Lieutenant Governor, submitted that the Delhi government had made illegal appointments which were terminated by the LG. At this point, the CJI inquired regarding the ordinance. He pointed out that the effect of the ordinance was that the appointment and transfers regarding the services will be taken away from the control of the Delhi government, though the constitution only bars public order, police and land. He said, and I quote, What you have effectively done is that the constitution says barring 3 entries, Delhi Assembly has power. But the ordinance takes away the entry 41 also from the power. That is the effect of 3A of the ordinance. Before this hearing on the ordinance, the court also made progress in hearing the dispute over the appointment of the Delhi Electricity Regulatory Commission chairman between the LG and the government of NCT Delhi. The details of the story are also in 2 of our previous videos, links to which are in the description. But the brief version of this story is that the Delhi government had recommended a name for the appointment of the DERC commissioner in January to the LG. The LG did not take any action despite the recommendation and then went on to unilaterally appoint another individual as the DERC commissioner. The Delhi government then filed a petition in the Supreme Court against this unilateral appointment made by the LG. The Supreme Court had then in a previous hearing deferred the oath-taking of the person appointed by the LG. On the 17th of July, this Monday, the Supreme Court told the LG and the government of NCT Delhi to amicably resolve the issue by coming together and coming up with a name and to, quote, rise above political bickering. Today, Senior Advocate Dr. Singhvi informed the bench on behalf of the government of Delhi that the discussions did not bring about any results and requested the court to defer the matter till the larger issue regarding the validity of the ordinances is decided. However, Senior Advocate Sarve, appearing for the LG of Delhi, urged the Supreme Court to appoint a person since the government of Delhi and LG are at a stalemate. And the Solicitor General of India, Tushar Mehta, appearing for the Union of India, also supported the court for making the appointment. Senior Advocate Sarve also suggested that the court may allow the present appointee, the one appointed by the LG, to function as the DERC chairperson since he is an appointment made by the President. The bench considered this suggestion, subject to the final outcome of the petition, but Senior Advocate Dr. Singhvi strongly opposed this arrangement. The bench then also suggested that head of some other statutory body be asked to discharge the functions of the DERC chairperson in the meantime, as the bench cannot allow the DERC to remain headless as it will affect public interest. This matter has been posted to Friday and the Supreme Court has decided to appoint a chairperson to the DERC itself. That's all we have for you in this video. Hope you found it informative. If you did, please leave a like and tell us in the comments how we can shape our content to bring you your legal news in more engaging ways. If you want to read the 2018 judgment or the 2023 judgment or find articles about this issue or get our latest updates, please visit our website at www.livelaw.in. Don't forget to subscribe to our channel and hit the bell icon for notifications. Thank you.